Okay, perfect. Let's get right into this. So basically, I had a call yesterday, and it happens once every couple of months. I get an individual who had a hearing, and that person who had a hearing had a friend. And that friend basically told them, hey, this Social Security disability hearing is supposed to have a decision within 90 days. And I tell them, yeah, there's a 90-day rule, but they don't really have to follow it. And they go, no, 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 no. I absolutely know they have to give a decision within 90 days. And I tell them, no, no, I understand that there's this 90-day expectation that they're going to, give you a decision, unfavorable, partially favorable, fully favorable within 90 days. But you have to understand there's more to that particular rule than just a quick little notation that, hey, they have to do within 90 days. So anyway, the person was very adamant about it. I said, okay, look, I'll go find the rule and then I'll do a video specifically on it. So this video is like a corrective situation for that individual being so strong about believing that the judges, when they have a hearing and you go to it and you do your thing, that they have to give a decision within 90 days. So let me explain how the government works with a lot of the rules that they create. Of course, we're doing the video a little bit earlier than normal today. Obviously, I'm not a normal early morning person. I'm more of a night person, but let's get right into it. All right. Section 416.1453. Again, section 416.1453. Let's go into it real quick. Subsection C, time for the administrative law judge's decision. All right. The administrative law judge must issue the hearing decision no later than 90 days after the request for the hearing is filed, unless. Okay. So here we go. The matter to be decided is whether you are disabled or there's good cause for extending the time period because of unavoidable circumstances. Good cause for extending the time period may be found under the following circumstances. Delay caused by you or by your representative's actions. The time period for decision in this instance may be extended by a total number of days of the delays. The delays include delays in submitting evidence briefs or other statements, postponements or adjournments made at your request, and any other delays caused by you or your representative. Okay. Other delays. The time period for decision may be extended where delays occur through no fault of the commissioner. In this instance, the decision will be issued as soon as practicable. Recommended decision. Although an administrative law judge will usually make a decision, the administrative law judge may send the case to appeals counsel with a recommended decision based on a preponderance of the evidence when appropriate. The administrative law judge will mail a copy of the recommended decision to the parties at their last known addresses and send the recommended decision to the appeals counsel. So let me go through again real quick. The administrative law judge must issue the hearing decision no later than 90 days after the request for hearing is filed, unless. Okay, so the point here is this covers kind of a broader, and I've seen people argue this multiple ways as to exactly, should the person have 90 days post initial filing for review for, hearing? Should the person have 90 days post hearing to go ahead and have a hearing decision rendered? I've seen this argued multiple ways. The bottom line is that the judges, they can really take as long as they want to make a decision. They usually take between 3 and 4 months. 3 months, obviously, being 30 days, 90 days total. But they can really take as long as they want to go ahead and, go forth and make a decision. Now, this angered the claimant because the claimant felt like, hey, they got to do what they've got to do. And the claimant was more of a military background than something else. So, it's got to follow the book. It's got to follow the law. But the reality is that when they make these rules, and it's specifically the government is required to do something, they put a whole bunch of requirements in there to allow the judge to have additional time if they want it. They do the same thing for the claimants as well. They do. They really do. Like, when the claimant has options, there's usually almost one little law at the very end that says, okay, but you can do this if there's some circumstance that allows you to sidestep it or move this way or go that way or whatever. So again, yes, there's a 90-day rule. I've seen it basically construed in multiple ways when it comes to how much time it takes for a decision to be rendered. But just so you understand, there's always all these extras in Social Security law that allows the judge to weave one way or the other or get a whole bunch of extra time. So anyways, I will catch you guys at the next video. The next video is pretty darn straightforward. We're going to go into it relatively quickly. I hope you guys had a wonderful night and you're feeling better. It is a super early morning for me because I was up super duper late. I see Diana Fernandez there. Excellent, excellent. Very good. I will catch you guys in about 5 minutes of the next video. Please remember to like. Please remember to subscribe, and we will go from there. All right. Have a wonderful, wonderful night. And thank you so much. All right. Bye-bye. Bye-bye.